The court reporter ends up getting so mad in this because I think they have to type everything down that's being said, and everybody keeps interrupting each other towards the end because they all get so mad. And the court reporter gets so mad.
I'm sorry to interrupt. The court reporter is trying to get your attention.
Okay.
You're all interrupting each other.
I will not be insulted. I will not be insulted. If you can tell me whether the First Amendment prevents sanction. Well, let me just start here in terms of.
This is like a Reddit argument. These are Reddit lawyers.
So does that answer the court's question?
No. And thank you for
No, it doesn't. Bro. Okay, you know what? We're gonna listen to this. There's just an infinite treasure trove of funny shit. And hearing it play out in front of federal judges is just so good. You know, some of the affidavits are like, they would say over and over again, we've got 1,000 affidavits, we have so many affidavits. But some of these affidavits are just so retarded. Like, why would you even submit these? There's like not even any information. Oh my God, I gotta find, somebody was making a list of just like funny comments in here. The court reporter ends up getting so ass mad in this because I think they have to type everything down that's being said, and everybody keeps interrupting each other towards the end because they all get so mad. And the court reporter gets so mad.
I'm sorry to interrupt. The court reporter is trying to get your attention.
Okay. I'm sorry. Andrew, Ms. Wabik, where are you? Oh, yes.
So, counsel, we've been going since 8:30
Oh, my goodness.
with 20 minutes,
Uh-oh.
and you're all interrupting each other. And that's the kind of record you want for a case like this. With interruptions, dashes, unintelligible. So please, can we finish up, or I'm going to have to get somebody else to finish this last little.
Oh, Ms. Wabik, let me apologize and say that I certainly don't want to. I know that you're under a great deal of stress.
So hold on. I think I probably will just listen to this. Not even for research, just because it's funny today. Hold on. Affidavits are still admissible to the same level as statements from a deposition or no? Yes, but affidavits are just like, an affidavit is just a person saying that he thinks he saw a thing, whatever. Like it's nothing. An affidavit doesn't really mean anything. It's just a statement that like a person wants to make. But it's up to you to decide if it's relevant or if it's good to have in court or. I'm not gonna find it. There is a oh God, hold on. I will find it. We're gonna sit here because you know what? We're not doing anything else. Wait, what is
us here today? But before I do that, I wanted to address Ms. Lambert Gentilla. Are you still with us?
Wait, I didn't.
Yes, Your Honor, I'm here.
Thank you so much. And so in your latest filing, you state that plaintiff's counsel had a First Amendment right to bring this election challenge, and therefore they could not be subjected to sanction. You further state, Counselor, that the U.S. Supreme Court cases that support this argument are just too numerous, quote, to mention, and any attempt to string cite them here would be insulting to all involved. I will not be insulted. I will not be insulted. If you can tell me whether the First Amendment prevents sanction. Well, let me just start here in terms of.
This is like a Reddit argument. These are Reddit lawyers. They're Redditor lawyers, right? Where they're like, oh, I should be able to bring any case I want. What do you mean, in front of in a federal court, like as a licensed attorney? Yeah. Okay, but what about like frivolous lawsuits or just stuff where you're not even like going through your affidavit? It's something called the First Amendment, sweetie. Sorry, have you ever heard of it? It's called the First Amendment. I can literally say or do any fucking thing that I want because of the First Amendment. Okay, it's called the First Amendment. Have you ever heard of it?
Is there a point where a lawyer's conduct becomes sanctionable and is no longer protected by the First Amendment? Because you
I think
quite broad.
Thank you, Judge. I appreciate the opportunity. The purpose of this.
She's not going to cite anything. These guys also, they had nothing to cite ever. The one, when I was just scrolling through this and listening to random things, the one thing I heard cited was they were like, well, there was a case in like 1825 or whatever. It's just like a 200-year-old. Like, what are you doing? Sorry, hold on.
Lawsuit, I heard the court address that earlier, whether or not it was an improper purpose or to the premise of it, which is show that the Michigan election was fraudulent. I think that these suits are critical to our country to show that every vote counts and ensure that every vote counts as it's intended to count. It's not a partisan issue to me. Everyone should be able to bring lawsuits to ensure election integrity, and the court system is the appropriate place to bring those suits. With regards to this particular case, the court didn't hear much about my role. I filed the notice of appeal before the court. Sydney Powell was lead counsel on this case. I've spoken with her no more than 2 times for brief conversations. I've had a number of conversations with Howard Kleinhendler, and all pleadings and briefs were prepared by Howard and Sydney even email responses to opposing counsel. I would check with them to see how they wanted me to respond, and then I would respond. I viewed my role as the local attorney. It was my understanding that they would apply to be admitted to the bar in the Eastern District of Michigan. I know this case was only alive for essentially 7 days before this court, before it was appealed. So does that answer the court's question?
No. And thank you for
No, it doesn't. She didn't respond to anyone. She just asked, can a lawyer do anything that's sanctionable? I love it. I love it. I love these settings. I love it.
Before it was appealed. So does that answer the court's question?
No. And thank you for letting me say that and let me restate again, pertaining to your position that plaintiff's counsel had a First Amendment right to bring this election challenge. My question to you, because I find that the brief itself is extremely broad in what you consider to be an attorney's First Amendment right in their capacity as an attorney in a courtroom. And my question to you is there a point where a lawyer's conduct becomes sanctionable and is no longer protected by the First Amendment? Or are you speaking of a right that is completely unbridled? Help me.
Your Honor, I think that an attorney's obligation is to be an advocate for their client. And as long as the attorney is putting forth accurate pleadings, accurate information before the court, which I have done, it is protected by the First Amendment and it would be unconstitutional. And the court is the appropriate place to redress grievances.
Okay, well, let me I want you to take some time and look at which is this big case from the Sixth Circuit is the Mezidov case, Mezidov, which I'm certain are familiar with, versus Allen at 411 Fed Third 712. And the Supreme Court has noted that it is unquestionable that in the courtroom itself, whatever right to free speech an attorney has is extremely circumscribed. Furthermore, it appears that no circuit court has ever actually granted an attorney relief under the First Amendment for this narrow category of speech.
Yeah, no shit. It's a Reddit lawyer argument.
Because an attorney by the
And there's so many lawyers that are roped into this insane, because they needed local lawyers to file cases. They had all these, there are so many people involved. This is just for one state, right? This would just be for Michigan because it's Whitmer?
The very nature of his job voluntarily agrees to relinquish his rights to free expression in the judicial proceeding. Our Sixth Circuit sees no basis for concluding that free speech rights are violated by a restriction on that expression. In filing motions and advocating for clients in court, an attorney is not engaged in free expression. She is simply doing her job. And I think that is, I was concerned, and you have not done anything to put aside my concerns, Ms. Lambert, that there is that is a circumscribed right that an attorney has when they are acting in a capacity as a lawyer in a courtroom.
There's a part where she's going over one of the affidavits, and she's like, so in an affidavit here, because Sidney Powell keeps saying we've got so many affidavits.
Yes, ma'am.
Yes, we filed a massive and detailed complaint in federal court that doesn't even require us to append affidavits to it. The very fact that we filed 960 pages of affidavits with the complaint shows extraordinary due diligence on our part.
What a stupid statement. I have 980 pages, so obviously due diligence was met. What do you think that means? You just add more and more and more shit? What an unbelievably stupid statement.
Virtually every question the court has raised about these affidavits calls into question the veracity of the affiance. And the only way to test that is in the crucible of a trial or an evidentiary hearing, which the court has denied at every stage.
All right. Well, let me just say that volume certainly for this court doesn't equate with legitimacy or veracity. So please understand that is certainly my position. Mr. Klein-Hendler,
yes,
very briefly, sir.
Yes,
very briefly.
With regard to this specific affidavit.
Yes, sir.
We have amassed evidence in Pennsylvania, and we've actually, we can present it to the court, I think we have it, where there was proof positive evidence of United States Postal Service. So, discussion of what very credible evidence that the United States Postal Service, believe it or not, had missed the thing.
The report, the reason that you did not submit any evidence on that.
Your Honor, at the time, I believe at the time we filed this complaint, we just had reports. We had one whistleblower who I believe we had interviewed. It wasn't yet hard enough, Your Honor, what I would call hard evidence to submit. However, should there be an evidentiary hearing at this point, we have the who, what, and where of what happened in Pennsylvania.
All right.
What and where.
Mr. Fink, quickly.
Your Honor, if I may, we are in the state of Michigan. We are not in Pennsylvania. And in the state of Michigan, they made this allegation based on some paranoid delusions of some witness who never even gets to a punchline. The fact is, if
Fink must be the, I guess for a sanctions hearing, I don't know how a sanctions hearing works. Does somebody have to bring a suit? So would they be the prosecuting, would he be like a district attorney or the state's attorney general? David Fink. Or somebody that just works at the bar? I have no idea. I'm not sure. I don't know what his official.
If they've got evidence, and he says they've got evidence, it should have been in the complaint. If they don't have evidence, or if they don't have direct allegations, then they shouldn't throw out these miscellaneous, defamatory, and frankly phony allegations. Now, this might all be true. If you read it closely, what it says is absolutely nothing. But it does fuel the fires of the online conspirators.
Fuck, I'm not gonna be able to find it. God damn it. There was some comment in here where I don't know if they go through a bunch of the affidavits, but the judge is going through some, and the judge is looking at one. It's like, okay, so here they allege that ballots, the way that the ballots were treated was perplexing. And I think Sidney Powell's like, yes, they were very perplexed. And the judge is like, perplexing. That's the affidavit, that the behavior was perplexing. And she's like, yes. And she's like, why are you wasting time filing this affidavit? This doesn't mean anything. What? That's worth filing in a court, that it was perplexing? It's just so funny how dog shit everything is here. I'm not going to be able to find where it is. Plastic bag affidavit analysis. Is this another one? We are absolutely listening to this.
14. There it is, right there. And the amended complaint states that Mr. Siantar independently witnessed while walking his dog, a young couple deliver 3 to 4 large plastic clear bags that appear to be, quote, express bags, end quote, as reflected in photographs taken contemporaneously to a U.S. postal vehicle waiting. The use of clear express bags is consistent with there's a whistleblower complaint that's been referenced in the context of this lawsuit. I have not ever seen any underlying documentation, but it's a whistleblower suit by a U.S. Postal Service worker, Jonathan Clark. Putting aside the fact that plaintiffs have not provided any evidence, as I just stated, regarding the Postal Service whistleblower claim, here are a few excerpts from the Siantar affidavit, which are now on the screen. Quote, I witnessed a young couple pull into the parking lot of the post office and proceed to exit their van, had no markings, and open up the back hatch and proceed to take 3 to 4 very large clear plastic bags out and walk them over to a running Postal Service vehicle that appeared as if it was, quote, waiting, end quote, for them. Let me go further. Quote, there was no interaction between the couple and any Postal Service employee, which I felt was very odd. They did not walk inside the post office like a normal customer to drop off mail. It was as if the postal worker was told to meet and stand by until these large...
Keep in mind that for these affidavits, when they talk about, like, this is the Kraken, this is part of the Kraken, right? That when they talk about these affidavits, Trumples will walk around acting like they were submitting forensically verified police, FBI investigations and shit with all this crazy evidence, this clear, concise pattern. This is what all the affidavits were like. All of them were like this. Also, we don't even know how much of this was written by the witness versus how much Powell's team helped them. Because we do know for at least a couple other affidavits that Powell's team was helping them write a more convincing affidavit.
Bags arrived, end quote. As you can see in the pictures, the affidavit goes on to say the bags were clear plastic with markings in black on the bag, and on the inside of these clear bags was another plastic bag that was not clear. You could not see what was inside. There were markings on the clear bag and what looked like a black security zip tie on each bag, as if it were tamper evident, as if it were a tamper evident type of device to secure the bag. This looked odd. What I witnessed and considered that what could be in those bags could be ballots going to the TCF center or coming from the TCF center. Now, this is quite a I don't
even know what the fuck I'm reading. I don't even know what are we even saying? Could be, maybe, possibly, could be, looks like, doesn't seem. Is that not criminal, Destiny? It should be. All of these people should be prosecuted. They shouldn't just be disbarred. These should be considered crimes. Abso-fucking-lutely. Or at the very least, like racketeering or conspiracy, like all grouped in. Abso-fucking-lutely. 1,000,000,000,000%.
Now, this is quite a, I don't think I've really ever seen an affidavit that has made so many leaps. This is really fantastical. So my question to counsel here is, how could any of you as officers of the court present this type of an affidavit? This is pure. Is there anything in here that's not speculative other than the fact that the individual saw individuals with plastic bags, they don't know what were in them, happen to be located at the post office, and then there's a leak made there? Someone answer that question for the court. Ms. Holler, thank you.
Yes, Your Honor. The witness is stating or setting forth exactly what he observed and his...
Thank you. That's what an affidavit is. Correct. Thank you.
Information that he bases it on, and he includes pictures with this account. He does not say more. He does not say less than what he knows to be true. It is a true affidavit. It is a person with some information, and he's setting forth that information. When we put the case together, we put forth a pattern of evidence that shows fraud. So it's a pattern of evidence that comes together. And
this is a Reddit answer, right? Or it's a Gish Gallop, unironically. Like I understand that like this affidavit is not convincing, but what if I give you like 150 other equally bullshit affidavits all together? Isn't it weird? Isn't it strange? Isn't that kind of weird? Like that's the entirety of this and all of this.
This is one piece of a pattern. He is testifying in his sworn statement as to what he knows to be true.
Counsel, I haven't seen this much hedging language since a Destiny stream.
He saw these plastic bags. He's explaining what he saw, and he takes pictures of them.
Okay.
It's not, I would submit, Your Honor, that it's not.
You haven't said anything. Julia Holland. These are all, I think everybody in here is an attorney, right? That's why I said don't trust lawyers for anything. Okay, don't trust them. They're crazy.
Fantastical. It's simply what he knew to be true.
You think that he is actually thinking that you think by the language in the affidavit, Ms. Haller, that he is actually stating that he believes his conclusions to be true when he says things like could be, it appeared as if they might have been waiting for him. Where is the truth in that? I mean, this is pure speculation. All right, let me move on. Is there any information on anything, Ms. Haller? Let me ask you this question. Was there any information? What information did the affiant have to make any of these conclusions in his affidavit? I mean,
also, they didn't bring any of these materials with them, by the way. And they don't show up any. We listened to this when they were talking about, I think Short was talking about how when they were doing these meetings, they're like, did you bring any of this evidence with you? And the judge yesterday, did you bring any of this with you? Any material for me to review? Never, ever, 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 ever. They never, ever, ever, ever bring anything with them ever because there's nothing. All of this was bullshit. All of it was bullshit. All of it. Every single part of this was bullshit.
Just stay with me.
Well, he was speaking in the present tense and he took photos. So he saw what he saw and he documented it as he did. He took photos. So he saw what he saw and he documented it.
Thank you. You said that. Yes. Thank you, Julia.
He did. And we don't typically rewrite what an affiant says.
Doesn't counsel also have...
Aren't you supposed to kind of like make sure that what they're saying fucking matters though? Like, isn't that kind of your job when you're putting together a case? Because you could theoretically go outside and you understand you can get an affidavit from anybody to witness anything, right? Like in terms of like, oh, did you see, John walking his dog yesterday? Yes. Oh, okay. Like you can fill that affidavit out and submit it as part of a court, but why? What is it? What is it furthering, right?
Don't typically rewrite what an affiant says.
Doesn't counsel also have an obligation to evaluate that and say, what is this actually going to prove?
Yeah.
He has made conclusions based upon what he's observed, but there is clearly within this affidavit nothing to support those conclusions. This is what he has. What else is there? This is anybody driving down the street and seeing somebody with plastic bags.
Okay, hold on, Judge, but I also have 500 other affidavits to say like really similar kind of weird things, right? Can that prove it? Maybe
you automatically jump to the point. And most importantly, Ms. Haller, counsel, what is your duty here? You said you don't rewrite the observations. Thank you. Absolutely not. But Ms. Haller, let me ask this final question and I'll let you speak. My question to you is that at what point do you have that duty to say, you know what, there's really not enough here? You don't feel that? I mean, at what point do you say that?
May I respond, Your Honor?
Yes, please do.
I would simply submit that we identified a witness as a potential source in a complaint to support information that we would then hope to call that person as a witness who would testify, would be anticipated to testify in accordance with what he or she had stated in a declaration or affidavit. This particular witness.
You're going to have them take the stand and you're going to say, so you actually saw a person put things in the bag, right? Yeah. Like, can you imagine what the cross would look like for that? Where, okay, like now let me ask the guys this question. So do you know what the people were doing there? No. Did you talk to them? No. Did you see anything inside the bag? No. Do you know why they were there? No. Do you have any reason to believe anything bad was happening? Well, I saw, no. Did you see where they came from? No. Do you know where they were going? No. Like, what could possibly come from this person testifying in court about anything? Like,
did not jump to any conclusions and made that clear in his affidavit. And he did believe, I believe he believed that.
I believe he believed. I believe he believed that it could be that maybe there was some malfeasance that could have been happening maybe.
He saw ballots, but I think he was hesitant to actually express that. And
oh my God, why would you say that? What? I think maybe he would have made a stronger statement on the affidavit, which is the only thing I can go off of because this is the only thing he's actually attached to. But I just don't think that he really wanted to say that right now. But I think he probably wants to make a stronger statement. Maybe in court he will. I don't fucking know.
That he saw ballots, but I think he was hesitant to actually express that. And his hesitancy comes through in his declaration.
Do you think his people are this dumb or paid off? I don't know. My mind is like a constant, what do you call is there like a more aggressive version of a metronome? Like I'm constantly ping-ponging back and forth between maliciousness and just unfathomable stupidity. I can't tell. I don't know. I truly don't know. Can there really be this many lawyers that have gotten together that are this fucking retarded They don't even understand basic process and procedure, because it's not even that we're just saying it's so much. It's so much. Pendulum, yeah, but like an aggressive pendulum. Like, this is insane.
Ballots, but I think he was hesitant to actually express that. And his hesitancy comes through in his declaration. But there is nothing untruthful about what he says.
All right. I saw another hand up.
Sydney.
All right.
It was Miss Powell, Your Honor.
Yeah, who called her out? Flanagan? Is that who said? Yeah, Miss Powell. Yeah.
He says.
All right. I saw another hand up. All right.
It was Miss Powell, Your Honor.
Uh-oh.
Ms. Powell, yes.
Yeah, go ahead.
Ms. Powell, yes, ma'am.
Yes, we filed a massive and detailed complaint in federal court that doesn't even require us to append affidavits.
Oh, wait, else it is. Okay, wait. I think Eben found the perplexing quote. Fuck. I only watched like 3 minutes of this earlier, so I don't know how many lay epic gems are in here.
Quote, perplexing and
Hold on.
the defendant's authorized quotes,
I want to know how many of these affidavits they go through.
systematic violations of ballot secrecy, end quote. One piece of evidentiary support that they provide is the Larson affidavit. The amended complaint specifically states, quote, Mr. Larson observed that some ballots arrived without any secrecy sleeve. These ballots were counted after visual inspection, whereas many ballots without a secrecy sleeve were placed in the problem ballots box. He found this, quote, perplexing and raised concerns that some ballots were being marked as, quote, problem ballots based on who the person had voted for, end quote.
Aren't there a lot of lawyers that aren't trial or litigation lawyers, so they're super inexperienced in processes despite being a lawyer for a long time? This is like someone having an undergrad in engineering but only work in a specific area. These people aren't even being asked to litigate. I believe that when you talk about like a litigation attorney, that's somebody that actually participates in court, presenting things and doing the court process like in court, right? That we're not even talking about litigation here. We're just talking about, like, I'm gonna say it's not even really legal stuff. It's just, this should be like a philosophy 101 class, okay? Like, okay, you've got 3 people here. All of them are saying that they saw a thing that kind of looks weird. Is that what you're building your case off of, ma'am? Like, you understand that nothing is actually being said here, right? We're not even really at a stage where you need some, or at least from my uneducated perspective, where you need some like hardcore legal analysis to understand what's going on. It's really just like basic, I don't want to say debunk conspiracies, but like just putting together a reasonable, well-supported argument.
Were being marked as, quote, problem ballots based on who the person had voted for, end quote. I would like to know if counsel would agree that Larson's being perplexed and his stated concerns do not serve as evidence that ballots were placed in the problem box because of who the vote was for. Can anyone agree to that, Mr. Campbell?
And I can't agree to what you have said, that somehow the word perplexed in describing his circumstances undercuts any of the evidence that's there. And it should be perplexing that somebody is picking the troubled ballots or the question ballots based on who's being voted for.
And you think that being perplexed by an observation is sufficient enough to get into court? Is sufficient enough to support an affidavit? Do you feel that constitutes evidentiary support, sir?
Absolutely. In this case, with all the other matters that are there, I'm shocked to hear a suggestion to the contrary.
Yeah. Okay. And and this is based upon your theory that all of these affidavits need to be viewed in context, right?
All of them need to be viewed in context, of course, Your Honor.
Mm-hmm.
How else would you view it?
I'm looking at them. In fact,
Ooh, getting snappy. How else would you do it? Bitch, that's what he wants to say.
Of course, Your Honor.
Mm-hmm.
How else would you view it?
I'm looking at them. In fact, individually. I understand.
Right, not in context. That's very clear, Judge.
Good.
Jesus. You understand you have a huge problem if none of these affidavits can stand on their own. You know that's like a significant concern, right? That should be bullshit 101. When somebody says like, okay, on their own, none of these things matter at all or mean anything or build towards anything. But if you take all of them together, okay, can't you, if you squint your eyes at it and you put them far enough away, it kind of looks like some weird shit, right?
Good, because I feel that any affidavit that is going to be submitted in support of any of these claims, there has to be a minimal belief on the part of counsel that these allegations are rooted in fact. And if you have language, excuse me, if you have language in an affidavit that is vague,
that's like maybe, kind of, could have, possibly,
and it's clear that this language is based on his own belief. He sees something that looks a little different for him, so he's perplexed by it. That's quite a low standard for submission of an affidavit. But I will move on.
He's perplexed. No, Your Honor, he's perplexed.
Oh, excuse me. You thought we were going to move on? Your Honor, hold up. I'm Donald Campbell.
because there appears to be a choice on which ballots get questions and which don't.
Even his language here is hedge. He's perplexed because there appears to be. And let me be clear here, okay? These affidavits aren't necessarily bad. The problem is that these affidavits should have been the basis for further questioning or investigation, right? So if you get somebody that's saying something like this, that's cause for investigation or concern. You should go and ask more people, okay? Gather more evidence. Like, oh, you saw something that looks weird? Well, let's go down to this place and interview some people. Or if we feel like we have enough evidence, get a subpoena and, force people to interview with the cops or something, right? That's what this should be used for. You can't just use that strange observation on its own as evidence of some malfeasance.
That, again,
isn't it fair to go to a court to ultimately decide within the context, even if likely false? No. You're not supposed to, I need to learn this part. I'm trying to think. What you're talking about, the investigation is an executive function and courts are for judicial functions. Courts are not supposed to be, would you say they're not supposed to be finders of fact? Like you wouldn't go to a court and then through the court, like get more investigations done. You would investigate first and then you would take your evidence to court. The court aren't the police. Even though we view them very similarly, like court and cops and prosecutor and judge, these are very, very, very distinctly separate things, right? The prosecutors and the cops are their own investigating things, and they go and they look for crimes, they look for evidence, and then they bring that to a court against a defendant, and that's how it's supposed to go. You don't take it all to court and then ask the court to do more research or whatever. It doesn't make any sense. It's totally fucked.
Because there appears to be a choice on which ballots get questions and which don't. That, again...
Appears to be.
There appears to be a choice on which ballots get questions and which don't. That, again, if this is the subjective nature in which this court is going to view the sanctions questions, which usually are objective, what can I do? But objectively, seriously, the word perplexed is what you think is worth the time and effort of all the lawyers, your staff on this proceeding to talk about sanctions.
And I ask you, did you really think that it was worth it to file in support of your claims that have taken up the time, energy, and space over these last several months? So I would caution you to do not.
True. Fuck. After listening to Kamala and this lady, I need a, is this racist or sexist or both? I need a black woman debate partner because they have the sass, okay? And they're just so good for baiting out. My God. I would be invincible. If I could just have a sassy black woman debate partner, it would be over. It would be over. It would be over.
Proceeding to talk about sanctions.
And I ask you, did you really think that it was worth it to file in support of your claims that have taken up the time, energy, and space over these last several months? So I would caution you to do not question my procedure. I'm here to question what you've done, sir. I'm here to evaluate. Hear me out.
And I am not a potted plant. I am not a potted plant. I will represent my client.
That is quite fine. But you don't worry about what I'm doing.
What did you say? I'm not a potted plant? Is that a lawyer saying?
Potted plant. I am not a potted plant. I will represent my client.
That is quite fine. But you don't worry about what I'm doing at this point. You are here to answer my questions, Mr. Fink.
First, it's probably not my place to say this, but I'm concerned by the disrespect for the court that Mr. Campbell is showing, particularly in light of the history of this litigation and how patient the court has been. I just want to make a quick comment regarding the reason that perplexed is such a significant reference in this particular affidavit. This is the affidavit of an individual who claims to have served as an assistant attorney general, claims to have some expertise in this area, claims to understand election law. For him to then just say he's perplexed by something rather than actually explaining where he sees some violation of law or practice, we thought that was significant when we saw it.
Oh, and the Thinkster, unfortunately, is familiar with the affidavit and read the affidavit. Oh, no, not good. No, who's this fucking loser?
A long time ago. My concern goes back to the same issue all along, and I'll get out and I'll stop here, which is just some diligence should have applied. What diligence is due might be a question for the court, but not when there's no diligence at all. And in this case, Mr. Larson's affidavit had already been reviewed by Judge Kenney and in many respects rejected, and counsel should have been, I believe, it's our case, I believe that counsel should have undertaken a serious inquiry to determine the facts before making all of these allegations.
Mr. Fink, we are available for an evidentiary hearing as we stand by every affidavit and document in this complaint. We did not file false statements. We made the documents clearly identified as they were. We did not alter documents. And any allegation.
What are you gonna accomplish though? And okay, this is gonna be like a rules of evidence question. An evidentiary hearing, I believe, is going to be where a judge decides if whatever evidence you want to submit to a particular case is going to comports with the rules of evidence, right? It's not going to be there. I don't believe it's there to determine if the evidence is good or bad. that's a question, one, that you should probably deal with before you even bring a case, right? That's up to you. I don't think you would ever rely on an evidentiary hearing to verify or validate the goodness or the trustworthiness or whatever of whatever evidence you have. So this idea that, well, we just needed an evidentiary hearing to figure this out, I don't believe that's what that's for.
False statements. We made the documents clearly identified as they were. We did not alter documents. And any allegations that we have done something that is improper really lacks foundation. And I would just generally say that going through each affidavit or each paragraph in the complaint will do so as Your Honor requests. I would just, for clarity, for efficiency's sake, ask that we, if we can, put it up side by side with the hearing so we can see where the paragraph is that we're talking about.
Mm-hmm. We'll try to do that. I have to admit that I'm a little surprised that counsel is coming to a sanctions hearing and does not have the documents that they themselves filed in front of them to be able to.
They didn't bring any of their shit. It's clown shit. This is clown shit. It's not even clown shit. It's like worse than clown shit. Would these types of hearings normally be recorded, or are we amazingly lucky that COVID happened? I think it's two things. I think we're lucky, and I don't think this was supposed to be recorded, because I think that generally federal court stuff doesn't like to be recorded. I don't know who recorded this, but this is federal. These are federal hearings right now. This is a federal court because they didn't like the answers they got in state court. So obviously now you have to file all your cases, refile them in federal districts. Like they somehow magically get jurisdiction because you're not happy with how the state court ruled, so that they try to go to federal courts next, which is not how federal courts work, by the way. But
answer these questions. But be that as it may, we will try to do what we can in terms of screen sharing. Yes, Mr. Campbell?
Judge.
I can't believe they didn't bring any of their own. They didn't bring any of their own shit. They just showed up ready to wing it.
As it may.
In federal court, in a sanctions hearing.
We will try to do what we can in terms of screen sharing. Yes, Mr. Campbell?
Judge, you're aware that you began this sanction hearing by saying it was your announcement of a show cause here today. These types of questions that you've asked were not raised by the defendants in their proceedings. And again, there's been a lot of opportunities for them to submit things. So I don't believe that statement about surprise or suggesting in any way that we've come here unprepared to look at the things that the court wants us to be directed towards. And again, you have had all sorts of opportunities to speak with the people who are responsible for putting together this complaint. And all
were they trying to throw? Maybe this is ridiculous. No, it reminds me of the. No, I don't understand. I just don't understand. It reminds me of when we listened to Giuliani. When Giuliani is before the court, and he doesn't understand what like a standard of review is. The court is the judge is asking him whenever. Okay, careful, shake it around. But whenever there's a law or something that implicates some kind of right of a citizen, there's a different standard of review depending upon what right is being implemented or implicated and which group of people are being affected. Right. So if it's like, let's say that you make a law and it says that the law says something like. If there's a red light and you're a pedestrian walking, you're not allowed to cross the street, right? Let's say somebody challenges that as unconstitutional. I say, well, hold on, my ability to move or some bullshit is being impacted. Okay, I shouldn't have to be told what to do for a stoplight. Well, for this, this is affecting all citizens evenly, right? Equally. It's not just affecting gay people. It's not just affecting women. And like, it's not like your right to travel is really being obstructed, right? So I believe, okay, Lord, correct me if I'm wrong, but I believe this would qualify for the lowest standard of review, which is called rational basis. Rational basis just means that the state just basically has to be able to say, this is why we have the law. Obviously it helps. And then the court's probably going to say like, okay, yeah, like 99% of rational basis review cases are going to be decided in favor of the state. They just basically have to put forward any argument that says like, yeah, this is the reason why we have this, obviously, right? Then you have two higher levels of review called intermediate scrutiny and strict scrutiny. And for these two levels of review, the state has to make a stronger case because usually some fundamental right is being implicated or a protected class is being discriminated against, right? So maybe a state makes a law that says, we've decided that in these gyms, we're going to say that only women are allowed to be here, right? Well, this is sexual discrimination. So that might be like an intermediate scrutiny or strict scrutiny review, meaning that for the state to have that regulation, that doesn't mean it automatically fails, but they have to put forth a really compelling reason for why they have a law or regulation that discriminates against some class of people, basically, or implicates some fundamental right. Giuliani, when he was in court, he was being asked over and over again by He was being asked over and over again by a judge, like, what kind of, fuck, I'm not even gonna be able to find this video. We watched this on stream a few weeks ago. He was being asked over and over again. He was like, what standard of review do you think would apply to this voting thing? And they go on for like 2 minutes, and Giuliani has absolutely no idea, like, what that even means. I don't know if even, I don't know. So all to say that when I'm watching these, I don't know what's going on. I have no idea what's happening. I truly just don't understand. I truly don't understand. Fuck, I wish I could find this video that we watched. Oh shit, it was here. It was this one?
Good. I want to turn to the merits now. What standard of review should I apply and why?
This is what Rudy was talking about, not constitutional standards of review. Well, so there's a very strong, we can steel man, and we can be very, very, very charitable for Rudy. And I think we can say that Rudy wasn't, hold on, fuck. Somebody emailed me an explanation of this. So let me just read this paragraph, okay? It seems to me likely that, or it's possible that Giuliani thought the judge was asking about the pleading standard rather than the level of scrutiny. And in a fraud case, the rule is heightened, and they talk about whether or not this is a fraud case. A party must state with particularity the circumstances constituting fraud or mistake, which requires a short and plain statement. But for fraud, you have to say more than defendant made a false statement of material fact. You need to allege who made the false statement, what it was, and when they made it usually. So when the judge asked for the standard of review, it seems that Giuliani understood him to be asking about the pleading standard. So he appealed to the regular standard rather than the heightened standard for fraud or mistake, which is why I said this is not a fraud case. While the initial misunderstanding started totally fair, perhaps for anyone who is a classic litigator who doesn't deal with constitutional issues and thus has never had to deal with levels of constitutional scrutiny, the fact that the judge explicitly said, let's turn to the merits, i.e. not procedure, and Giuliani said he didn't understand what the judge meant by strict scrutiny, destroys charitability after this point. So like maybe in the beginning he had a misunderstanding here because he was thinking of a pleading standard, but like the fact that he just had no idea.
What standard of review should I apply in this case?
On a motion
it's just
well, I mean, I think the normal one, which is that you have to deem the factual allegations to be correct, and even if they are correct, you have to find that there's no merit, no legal theory on which we can get relief.
Well, let me ask you, are you arguing then that strict scrutiny should apply here?
No, the normal scrutiny should apply. If we had alleged fraud, yes, but this is not a fraud case.
So if that's so, what's this background noise?
Oh my God, there's Zoom shit.
Baron check, are you moving around again?
I just want you to remember I'm here. I want to say a couple things at some point.
Oh, well, we'll get back to you. We haven't forgotten about you. Try not to move around. So if that's the case, why don't Secretary Bouquevards and the counties satisfy the standard review that you're talking about? If it's not strict scrutiny and it's the standard review you're implying, why don't their actions satisfy this?
I'm sorry, I don't really understand the question, Your Honor.
Well, this is how I would look at it. I would think that it's a standard review of strict scrutiny potential. You're not sure that that's the case. I'm not imposing my.
Maybe I don't understand what you mean by strict.
Well, for strict scrutiny,
I don't know. And again, this is where Pisco's saying there's no more charitability. So I tried so hard to be charitable. Like maybe this is some shit you learn in law school and you don't like remember, right? One thing that I'll say as a general matter is that as a layman, it's possible that you could, in a very quick amount of time, learn something that a highly educated person doesn't know just because you just don't remember it or you don't study it. Like there might be some weird term. Like you could find like the best program in the world and probably dive into a comp sci book and read some random shit and he just like doesn't remember some like crazy random thing. So I'm thinking maybe that could be. Now, I don't know if like standard of review is something that you would just be utterly clueless about, especially when you're challenging like right to vote and stuff and you would have never remembered this or anything. I don't know, but like that maybe.
Apply a fundamental right needs to be burdened, as I understand it. So,
but the problem is that right here, he's explaining, okay, so, oh yeah, the judge even says it. I can't even believe he's doing this. I think the judge is very friendly towards Jill. I think they went out, he gave him like suggestions for restaurants to eat and everything. Although I also read that that's pretty standard. The judges like it when people come to their district because they like to recommend. But like, he's explaining exactly what the standard of review is.
Imposing my.
Maybe I don't understand what you mean by strict.
Well, for strict scrutiny to apply, a fundamental right needs to be burdened, as I understand it. So how?
And then this is when Julie, oh yeah, obviously. Oh, you're talking about standards of review for, oh, okay, yeah, I understand.
But the counties or Secretary Bukvar, on behalf of the Commonwealth, burden the plaintiff's right to vote? How do they
because
burden the right to vote?
based on issuing these opinions that are confusing, ambiguous, in several instances contrary to the law, it's very, very hard to have consistency in the principle. Let's stick to the one we've talked about most often, about whether you can cure a ballot, whether you can supply the information after the fact. She created a great deal of confusion about that and never clarified it.
And this is just stupid. This is like philosophy 101, right? Like, do you have a right to vote? Yes. Do you have a right to cure a ballot? I'm not sure. But whether or not curing the ballot was done in an inconsistent way contrary to equal protections provided by the 14th Amendment, or whether it implicated some fundamental right, is a fundamentally different question than do you have a right to vote. You can't just connect these two things and say they're the same, right? And I think the other attorney that comes in tries to salvage it from Giuliani, who clearly is, I don't know if Giuliani ever litigated a case in his entire life. I don't know if Giuliani ever prepared any legal anything in his entire life. I know he got a lot of credit for taking down the mob and everything, but I don't know what his involvement was in those cases. And listening to Giuliani's conduct in these cases, he either forgot everything, suffers some kind of like severe dementia, never actually tried any cases, and just like went through law school, graduated bottom of his class, passed the bar, and then got elected because he was friendly or whatever, or he's fucking lying and acting maliciously. I have no idea, no clue.
All of the attorneys, all sorts of the things that the court wants us to be directed towards. And again, you have had all sorts of opportunities to speak with the people who are responsible for putting together this complaint and all of the attorneys who stand behind its filing.
All right, thank you. I'm going to now go to the affidavit of Mr. Gustafson.
Oh my God, she goes through them. Oh my God, it's so cringe. Okay, we're absolutely listening to this all today. I can't help myself. It's just so funny. We'll do other stuff first. We'll do the entertaining shit first. Wait, I just want to hear this last affidavit real quick. I'm so sorry.
Gustafson. That's set forth at ECF number 6-4 at PDF pages 48 through 49. Now, plaintiffs allege that unsecured ballots arrived at the TCF Center loading garage, not in sealed ballot boxes, without any chain of custody, and without envelopes after the 8 p.m. Election Day deadline. They provide 3 pieces of evidentiary support, and I want to look first at the Gustafson affidavit. That affidavit states, quote, large quantities of ballots were delivered to the TCF Center. Here we go. Large quantities of ballots were delivered to the TCF Center in what appeared to be mail bins with open tops. These ballot bins and containers did not have lids, were not sealed, and did not have the capability of having a metal seal. The ballot bins were not marked or identified in any way to indicate their source of origin. My question to counsel at this point is, what is counsel's understanding of Michigan's requirements as to the container ballots and how they are to be transported after they've been removed from the ballot drop boxes?
Oh no, you better know the procedures, right? Remember when you're when you're going to a court and you're submitting stuff saying that a law has happened, or I'm sorry, a law has happened. A crime has happened. You would say like prima facie has a law actually been broken, right? So let's say I get is it affiant? What do you call it? An affiant to sign an affidavit saying yesterday, John looked at Jane crossing the street, and then you submit that to the court. Well, the court will look at that and they'll say, okay, like, is there even a law broken here? Like, this is why ordinarily when you see us read indictments or charging documents, right? Generally, when we look at an indictment, at the bottom, they're going to list the specific, wait, do they on this one? Hold on. Yeah, they're going to list the charges, the criminal charges, the counts. They'll say, this is the crime that you're breaking right here, or not crime. This is the statute that you're breaking. Generally, it'll say like, we're reincorporating the text from 1 through 44, and then this is what we're saying they're doing to break this particular statute, right? But in order to say that you've broken the law, you at least need to know what the law is, right? All this to say, I haven't listened to this yet. Well, fuck, maybe he will know. If they respond with something like, well, we're not really sure I feel like he's going to say, we don't really know what the Michigan laws or statutes or regulations are, but we'll get back to you on that, but we'll see.
And how they are to be transported after they've been removed from the ballot drop boxes. In other words, what do you understand about the requirements here for ballot bins?
Your Honor.
Yes.
I would just say we do not purport to be experts on Michigan's process.
That's unbelievable. What an unbelievable answer. You're submitting the complaint alleging that some law has been broken or some process or procedure has been violated. And you're going to say, well, I'm not an expert. Well, then why the fuck are you filing the complaint? If you don't even know if a law has been broken, you're wasting everybody's time. You're wasting the court's time, right? Hey, here's a 980-page complaint. Can you go ahead and read through this? Do you even know what the fuck, if any of these laws have been broken? What an unbelievable answer. To federal court also. This is federal court. And the only reason they're going to federal court is because they got shut down in state court, right? So what an unbelievable due diligence, by the way. Yeah, this might be considered, actually, I don't know if there's a legal definition of due diligence, but in a layman's sense, you might consider this your due diligence, right? Did you actually see if a fucking rule or a regulation was actually being broken? Did she get roasted for this answer? Hold on.
Your Honor.
Yes.
I would just say we do not purport to be experts on Michigan's process, but I would point out that these exhibits are these Larson and Gustafson are exhibits to a filing in the Constantino case, which is attached to it's one of the exhibits that I believe Your Honor is referencing. So these are exhibits for the court as information that has been filed in another court of law.
What? She says so much without saying anything. I'm glad the judge called her out on it before when she was like, does that answer your question? And the judge was like, no, it doesn't. It doesn't at all. She says so much and she doesn't say anything.
Just for
as has been stated, Ms. Haller, a few times. And again,
but we're in a different document, Your Honor.
Well,
this is for the state of Michigan, right? My name is Daniel Gustafson. I'm an adult citizen and resident of the state of Michigan. So whatever case this is attached to, it still involves Michigan, right?
Has been stated, Ms. Haller, a few times. And again,
but we're in a different document, Your Honor.
Well, I mean, yeah, but we're still dealing with the same kind of scenario with affidavits having been filed. Are you saying that this particular affidavit was filed in the Constantino case?
Yes, I'm saying this is Exhibit 6-4B. I believe it's B, as opposed to Larson, which is A. And then there's a C, and that these are exhibits to a filing by Constantino, which the whole thing was attached.
Okay. Again, I think that, again, the court and counsel have a different view, and that's clear throughout this hearing as to what obligations. And again, I really just want to clarify that the court, I know that none of us are experts in elections. We're not necessarily experts in Michigan election process, but the bottom line is that if you're going to file an affidavit, in this court's view, there should be some general understanding of the process, such that when you see a statement by an affiant that you're willing to submit as evidentiary support. Is that not why an affidavit is being filed?
Yes. It's not even like she's just like stating like an obvious basic fact, right? Why the fuck would you again, I've said this like 4 times now. We could go down to a courthouse. We could file 1 billion affidavits with 1 billion affiants stating anything, right? Like yesterday, Frank looked up and the sky was blue. Yesterday, I was offered peanuts by an airline steward or stewardess. Like, okay, yeah, and what's the point of this?
If you have not asked at least the minimal questions, I find that problematic. And I'm just trying to determine the level of inquiry that has been made here. And I really do think that that's a misunderstanding that counsel has in terms of where the court is going. And
Now, this is where I would bully the judge and I would shit on her and I would say, because she's pulling a Pisco right here, okay? A misunderstanding, Your Honor? This is not a misunderstanding. This is malicious, okay? This is maliciously done. Although actually it's probably not the judge's point to say that because she's just the judge, not the prosecution. So, but.
And I won't entertain at this point any argument as to why you would think that that's an inappropriate inquiry, because I feel that it is an appropriate inquiry. Mr. Fink?
Yes. Your Honor, this allegation by Mr. Gustafson, the statement by Mr. Gustafson occurred in the Constantino case. And so in that case, on November 11th, Christopher Thomas did file an affidavit explaining that there is no requirement that ballots be transported in sealed ballot boxes. He's not aware.
So it's not even, there's not even like a violation or anything alleged here. It's just, this is just a worthless affidavit.
Of any jurisdiction in Michigan sealing these ballots prior to Election Day, and employees bring the ballots to the TCF Center consistent with chain of custody. They weren't just left out someplace, but that's a factual statement. I could be wrong. I don't think I am, but I could be wrong. But what's important is they certainly were on inquiry notice. Once this affidavit was filed by Mr. Thomas, once they'd seen this other litigation 2 weeks before they filed their case, all they had to do was ask. And if they'd asked any election official in Michigan, any clerk in Michigan would have told them, we don't even have sealed ballots for transferring ballots around. After the vote count, yes, you seal the ballots. But before the vote count, you can't seal the ballots. And they're not sealed and they're not transported that way. It's them saying, we are not experts. Tells us all we need to know. They didn't get experts.
True. That's true too. You don't have to be an expert. That's the wonderful thing about court. You can find an expert to testify for you. That's the whole point. Or not the whole. That's an option, right?
They're not experts, and nonetheless, they threw this information in front of the court, hoping something would stick.
Yep.
In the most important litigation imaginable.
Yep.
Thank you, Mr. Fink. Mr. Campbell?
I hear Mr. Fink not taking any issue with the facts that are described in the affidavit.
Because you haven't even alleged a crime. He's a Redditor.
Mr. Fink. Mr. Campbell?
I hear Mr. Fink not taking any issue with the facts that are described in the affidavit. I'm
Right, they don't mean anything. Oh, I'm sorry.
Thank you. Yes, correct, Fink. Yeah, no, that's okay. It's okay. Interrupt him. Okay, embrace your internet debater. Yes.
Well, they mean something. Somebody has to say it, right? And all you.
What? Okay, my bad. See, this is where I get owned, okay? Because earlier I said you could just file an affidavit literally saying anything, all right? And now when I said that, my assumption was obviously you wouldn't do that because I'd be retarded. But now I think Donald Campbell is about to make the argument that, well, actually, you can just do that. You can just submit whatever the fuck you want and throw whatever you want into a court because courthouses have infinite amounts of time. They can go through infinite amounts of paperwork, and who the fuck actually cares at the end of the day? My bad.
The affidavit.
Right, they don't mean anything. Oh, I'm sorry.
Well, they mean something. Somebody has to say it, right? And all you did is produce another affidavit that said, yeah, that's what's done. But until the first person said it, the second person didn't comment on it. And I think you.
That's not how any of this works. What?
Can take some notice that things that are unsealed, that things that are unprotected, that things that are not, that are handled in the manner that even Chris Thomas says. I've never met Chris Thomas. He's not here. We don't even have the chance to go over his affidavit in this kind of detail.
You know what, Zaz? You just typed that as a joke, but it actually illustrates a really important point. You said you can make an affidavit on a ham sandwich. You know what? These motherfuckers will look at federal indictments and they'll go, oh, you can indict a ham sandwich, but they will hang their hat on and bank their entire reputation on fucking affidavits as part of a court case. They'll do that. Federal indictment, so who cares? That doesn't mean anything. Affidavit signed by this guy, that's Keno. That's some cash money testimony right there, okay? Absolutely. That's all we need.
To do that at an evidentiary hearing. But all this is a fact of what somebody saw. And in fact, it appears that you're here to testify that it's true. So how is it, what more diligence was needed to produce a truthful affidavit for you?
Truthful affidavits don't mean anything. You have to be breaking a law or procedure. Otherwise, what the fuck is the point of the affidavit? What is the response? Well, I don't understand this question.
Apologize, Your Honor. I should not have asked him the question directly.
All right,
I can speak to it only if the court wants me to.
Yeah, let me just say again, I feel like I have to respond again that, I need to point out here that my concern is that counsel here has submitted affidavits to suggest and make the public believe that there was something wrong with the election. Isn't that what this is all about?
Yep.
That's what these affidavits are designed to do.
Yep.
To show that there was something wrong in Michigan. There was something wrong in Wayne County. These are the observations of what took place at the TCF Center. I am simply taking those affidavits, which counsel submitted in support of the general proposition that there was fraud in the Michigan election. I'm looking at that, looking at the language of the affidavit and saying, is that what this even says?
Exactly. And when she asked that question, is that what this even says? This is the prima facie question, right? Have they even said anything in the affidavit that would break a statute or a procedure? Is there even anything that is a law even being broken? Or is this just a random fucking statement by a random fucking person that means nothing?
I'm looking at that, looking at the language of the affidavit and saying, is that what this even says? What level of inquiry have you made to even know? I mean, for a person who doesn't have a lot of experience, maybe they some of them, of course, I know the poll challengers went through a training and so forth. But the bottom line is that if you see something and you're not that familiar with the process, it doesn't always mean that what you're seeing is what you think you're seeing. It doesn't matter that it doesn't always mean that what you see is being odd, that it is in fact odd.
See, then she shouldn't even explain this. She shouldn't even explain this. This is obviously true. And all of these people obviously know this. This is obviously true.
If you don't know the process, all I'm asking, counsel, is if you took the time to look at those affidavits and say, well, wait a minute, there might be something here.
Why wouldn't you take the time to go and check the relevant regulation or the relevant statute to see if anything like bad had even happened? Or why wouldn't you interview other people related to the affiant to see if anything bad actually happened?
In the sense of, is that part of Michigan's process? That's my question. Were that type of inquiry made?
Did it ever happen a single time? And the answer is no. The answer is no. How are you going to answer this question without seeming crazy? Did that ever happen?
And it's a germane question because the premise of this lawsuit is that Michigan
that a process, that some type of statute or regulation was broken. That's the whole premise of the lawsuit, is that something illegal or something that was contravening what should have happened. But you don't even know what should have happened. How can you even file the lawsuit?
And it's a germane question because the premise of this lawsuit is that Michigan's election was fraudulent. All right. So, Mr. Klein, I'm sorry, sir, Mr. Klein Hendler.
Yes, Your Honor.
You may comment briefly, sir, and then I'm going to move on.
Yes. I can't say I reviewed some of these affidavits. People working with me reviewed every single one. I believe we did speak to some of them. I think we did speak to some of the attorneys. At least that was my understanding. And with regard to your specific question, it's just basic knowledge that when you're transporting.
I can't even believe he just said that. I could do this. I could do this job. What do these guys get paid? What? I can't even believe he should be barred. He should be disbarred just for that comment. Just for that comment. Like, you will never, on this stream, we will never in our lives, okay? And I'll retire, okay? I'll make the Dave Rubin promise. If we ever go over a federal or state indictment of somebody, and by the time we hit the bottom, it says there's no like count one, count two. There's none of that. It just says it's basic common knowledge that this dude broke the law. You know, we're going to reincorporate lines 1 to 72 and say it's basic knowledge that this was wrong, right? You will never, ever, ever see an indictment that says anything like this. Now, I understand we're talking about a criminal matter here but even on a, where's the Finkelstein PDFs? Even on civil stuff, you have to, they have to be doing something wrong. They have to be doing something incorrect. This is civil litigation, Dominion versus Mike Lindell. They even on a civil suit, they're saying like, here's what they're doing. You know, deceptive trade practices. The ones that we read with Dan. Like you have to do this. But like, this is obvious. It's so obvious. Like, what are we even doing here? What happened? How did these guys get? Did they go to school? They passed the bar, right? What's going on here? What's happening here?
And with regard to your specific question, it's just basic knowledge that when you're transporting a bunch of documents in an unsealed container that can be tampered with from a remote location, that raises a suspicion.
If you have an issue with the process, then you need to change the law, right? Let's say that if everything you're saying is true, then you should propose a new law. But there's not anything happening here that's improper.
Whether it's required under Michigan law or not is completely irrelevant.
Then what is the, I'm sorry, maybe I should read what is the court case about then? If we're saying that the law is irrelevant here, then what are we even filing for? Rewatch and look at the judge's reaction? Okay, hold on. What is the point of the suit?
Porting a bunch of documents in an unsealed container that can be tampered with from a remote location, that raises a suspicion. Whether it's required under Michigan law or not is completely irrelevant. We're not saying here even that Michigan poll workers knew that they might be doing something wrong. We have alleged here that there was things going on that maybe even some of the workers themselves unknowingly let slide through. And so I want to make that point clear. If you're bringing something from far away.
And also, this is like civic stuff, okay? Also now, imagine, like, what you're saying is so impossibly inappropriately stupid now, too, because keep in mind, now they're in front of a federal judge, they're in federal court with federal jurisdiction, and now you're saying that that Michigan poll workers were doing things that didn't even break Michigan law, but maybe there should be a law against it. What is the federal jurisdiction to even hear this case? So what are we hoping to get? Like, what is the relief they were seeking? I'm curious. In this case, King et al. V. Whitmer, what relief were they looking for? Can somebody find like the original complaint here? Do you want a federal court to change I don't even know. I have no idea. I don't even know. I have no idea. I'm not even sure. Like, what are you even asking for?
And it's open, that raises an issue. Your Honor, if I handed you a can of Coke that was open and I told you, don't worry, I didn't drink from it. Okay.
These are elections that have been run in the state of Michigan for years. The analogy is certainly not on point, sir.
Yeah, what are you talking about? What? Not the Coke can? Don't you mean Diet Coke?
The state of Michigan for years. The analogy is certainly not on point, sir. It is not.
The second point I'd like to raise is the notion that we filed this lawsuit as some kind of public relations. That is not correct. We filed this lawsuit on behalf of clients who were electors who asked us to file this lawsuit. What the public did with it or didn't do with it is beyond our control. And
it is. You're the lawyer, though, right? The reason why you don't do, pro se representation, that's what we call it, right? The reason why you don't represent yourself in court is because you go to an attorney who is more experienced with the process to tell you, hey, do I have a case here? Is there anything actually happening here? You don't just take every single random fuck case that a person brings you. That's part of your responsibility as a member of the court, right? This is why you're barred. This is why you're part of the whatever lawyer fucking associate. This is part of your responsibility to the court. Courts have limited time, okay? If you've ever been to court, you'll see. You go to fucking traffic court, okay? There's people who shuffle in and out of here all day long. The courts are backed up like crazy. The idea that you could just file whatever the fuck you want because some random fuck person comes up to you and is like, oh, we want to fucking sue somebody? Like, bro.
Reject categorically the mantra you've heard in the papers and you're hearing again now, that we did this as a publicity stunt. To reject that wholeheartedly, Your Honor. We did not. We filed it on behalf of plaintiffs who asked us to file it. And
that's not an argument, my friend.
I'd like to make that point clear.
Okay, and again, the analysis will always be, and part of the analysis in certain of the sanctions that are available to the court is, was the purpose for which the lawsuit was filed, was it an improper purpose? And this is also, I think that things can also be drawn from the amount of effort that you put into a lawsuit in terms of what are you really trying to do?
Like, he gave the Reddit answer or the Rob Noor answer or some conservative answer, like, whoa, well, we just do this. And she's giving like an obvious, like, okay, well, we can just look at the amount of effort you put into the case and see what the is going on, right? Like, that like this bullshit, this like cutesy Twitter answer is like, this is bullshit, right? It's very obvious that we can look and see what you've done. And it's pretty obvious that you didn't give a about actually trying to make this case work. You're just wasting everybody's fucking time, right?
And I've not drawn any conclusions at this point, but I am trying to, again, drill down.
Your Honor, and I just want to leave
Excuse me, Mr. Handler, I have not finished. I am trying to drill down as to the level of inquiry that was made by counsel in these multiple affidavits. All right, and there is no...
The scary thing, too, is they don't even know how to lie well. Like, you could have at least tried to reach... Like, there are better ways to fake this case, too. There are better ways to have perjured yourselves here. Or would you consider perjury? There are better ways to have done this in bad faith, right? Like, you had no problem getting so many different poll workers and shit to sign these bullshit affidavits. Why not just go find one election rule? You've got to be able to find one Trump sycophant, okay, who will swallow just one load for Trump, who would be willing to say, like, oh, yeah, like, I am familiar with the rules and procedures, and I feel like they were broken in this way. You've got to be able to find just one of them, right?
No way that I could not do that.
So the lawyers are basically scamming the Trump campaign? I mean, well, no, because didn't Trump's campaign raise a bunch of money? All these people got paid to do this work, right? Like, as a lawyer, you're getting paid, by the hour. Your office, you're billing per hour for all this bullshit ass paperwork, all this bullshit. I'm sure Sidney Powell is that public statement? How much money did Sidney Powell make from Sidney Powell's group raised more than $14 million spreading election falsehoods, inspired by her fight to reverse the outcome of the vote. So everybody working on this got paid handsomely for it. Oh, and another $2 million by the next year.
In these multiple affidavits. All right, and there is no way that I could not do that and then put myself in a position where I could accurately assess whether behavior here has been sanctionable. And when I say here, I'm talking about through the course of the litigation. All right, I'm going to move on, counsel, to the Myers affidavit. And Meyer
The fact that conservatives think you can trick the court with anything might be the reason they think the courts are all rigged. Maybe. Where the is Pisco at? Where is that cuck, that fucker, Pisco? Where is he? I think there was a darker strategy that was lurking in the corner here. That as I was listening through more stuff yesterday, I think I understand. We'll see if he joins later. Okay, we'll listen to the rest of this later. Hold on. What is this?
Mr. Campbell, let me ask you something. Do you agree that the state law establishes an extensive procedure for challenging elections?
Yes.
All right. Did the plaintiffs avail themselves of any of these?
Third, so explained and gone over in the Supreme Court filings. Duration, these not just voters, all 6 of the plaintiffs. So those statements are statements by uneducated people.
Yeah, I'm going to get into those statements.
Thank you. So those things all combine to show that using what was available to determine a path. And then remember, Judge, this is very important. 3 of the plaintiffs, and that would be King, Sheridan, and Haggard. They are not just voters. All 6 of the plaintiffs are voters. And every vote is important under the Constitution, under case law. But these 3 are electors. And in order to bring their claims, it was the consideration of counsel in this case that certain acts had to be completed by the state. The state finally completed those on November 23rd. And this was all also explained and gone over in the Supreme Court filings. The last acts were done by November 23rd, and this case was filed on November 25th.
Mr. Campbell, let me ask you something. Do you agree that the state law establishes an extensive procedure for challenging elections?
Yes.
All right. Did the plaintiffs avail themselves of any of these procedures?
No.
And why is that?
What?
What's up?
Oh, fuck. I think I might read this case at some point because now I feel like it might be important, but it's on the docket for later.
What case?
Okay.
What do you need from me?
Okay. I was listening through, I think it's Short and Anthony, I think, where,
Short and Anthony.
I think it's, what is it? Is it Mark Short and the other, Mr. Jacob.
Mr. Jacob.
Yeah. I think it was a VP counsel.
advisors.
Yeah. I feel like, so Jacob, when he was talking about Eastman's statements, there was something darker lurking in the background, and I think it makes me understand a lot of these court cases more. You've heard that quote where Mr. Jacob was saying that Eastman said they'd probably lose in the Supreme Court 7-2-9-0 if they had to rule on it, right?
Yeah.
Okay, I listened through more of his testimony, and there was something darker that came out later on that Mr. Jacob said, and that's that Eastman said, basically, we won't have to worry about this, though, because the court will probably punt it because of the, what's it called, that major political decision?
Political question.
Yes. So I wonder if a lot of these cases are being filed in bad faith because of 2 major assumptions. One is that Donald Trump can always pardon you of federal charges, which he's shown he's willing to do for anybody. And 2, if it were to ever go before the Supreme Court, they would always just refuse to hear it because of the major questions doctrine.
Be careful. There's the major questions doctrine
Yeah.
and the political question doctrine. Don't confuse them.
Okay.
They're extremely different. The major questions doctrine is essentially a rule of statutory construction.
Mhm.
It says we're not going to read into these kind of general statements like you can waive or modify any provision of the student loan program, and we're not going to read that into, well, Biden can just wave his hands and get rid of all student loan debt. That's the major questions doctrine. You might disagree with it as applied in that case.
Sure.
But that's what it is. A rule. It's like Chevron.
Major question is basically saying that, like, we're not going to okay like a form of statutory construction that allows for a massive thing to happen that wasn't like explicitly written.
Yeah.
Okay. Yeah.
It's rule of construction, but it's people apply it in one way, not the other, and so there's a lot of criticism. But it is at bottom the court deciding the question of statutory interpretation and saying what the law is.
Mhm.
So that's very different than the political question doctrine.
Okay.
The political question doctrine says. There's a case that kind of established it, and now we kind of recognize it as 2 little branches. That the court is saying this question cannot be resolved by the court, either because A, this question was given to another branch of government. So, say for example, the power of impeachment. The group that has sole power of impeachment is the House of Representatives, and so the court cannot, at any time, look into maybe they're at the edge, the perimeters, you could say, that they could see if there was a procedural correctness in the impeachment. Did you get enough votes to impeach? Maybe.
Yeah, I gotcha. Okay. So it wasn't the major questions; it was the political questions thing.
Yeah.
But but Mr. Jacobs says that after Eastman basically admitted that they would lose if it went before the Supreme Court, his view was that the court simply wouldn't get involved because they would invoke the political question doctrine, and therefore they had.
What are they saying there? What they're saying is the court would say, "Hey, this question about whether or not the Electoral Count Act was done correctly, that's a question for the political branches.
Yeah.
The Constitution puts it in the hands of the vice president or in the hands of the branches of Congress to figure that out.
Mhm.
It is not a justiciably resolvable case by the courts, and so we dismiss."
But what they're saying is a step further is that if the certification on January 6th had been stopped, there was basically nothing that anybody could do for whatever, because like the Supreme Court would never touch it. So even if they're saying, well, if you guys don't like what we're doing, you can challenge it to the courts or whatever, that was never true because their opinion was that a court would never actually touch this thing anyway, and they could just carry through unobstructed, basically.
You've entered a new state of being, Stephen. You've entered a pseudo nirvana state because this is essentially what you're saying at the moment.
Okay.
The argument from people that you'll hear, the bad faith argument, the argument that you should reject is...
Wait. Somebody's talking about her. Hold on 1 second. If I die, I love you. Okay.
Yeah, always have. Where were we? Oh, you had reached the new state of nirvana.
Yeah.
The bad faith argument that you've been approached with is that this was just a legal theory. How many times have you heard that, Stephen?
I've already, that's also that 12th Amendment and constitutional are code words for breaking the law.
Yeah.
Every single time they invoked the 12th Amendment, they were doing so to say that they can break the law for the ECA. That was the only reason it was ever invoked. And it was a bullshit legal theory. But yeah, go ahead.
You have reached either inadvertently or advertently that part in Inception when you are like, fuck, what is it? Like the world between worlds or whatever. You've reached it because now you've discovered absolute evidence that at least if you believe him in this place, that is Eastman, he was never intending these legal theories
to be tested,
actually tested in a court of law. And so the ultimate thing that's going on here is if it's just a legal theory, who gets to test it? Well, the people who implement it. And so the people who did it are the ones who determine whether it's legal, not the courts of law. And if that's your position, if your position is the people who say it's legal are the people who are doing this legal theory, then in what world is that a legal theory that we should be accepting? It's like as though the robber were testing the legality of his own robbery, or the thief were testing the legality of the fact that he stole the diamond. It's the ultimate bedrock that shows they didn't actually want this to be litigated in the court. What they wanted to do was win. What they wanted to do was steal the election. That's what they wanted, and they would have taken any situation that got them there.
Yeah, and then after that happens, they can figure anything else out. As long as Trump is in office, you've got pardons, you've got mucking up the courtrooms, you can do whatever the fuck else you want because you have infinite time now. Yeah. And
this is the ultimate black pill. Imagine that the court, that the vice president actually did declare that this, they had dueling states of ballots, and for whatever reason, they were able to have it so that the House of Representatives by state delegation voted for president under objection, and they said that Donald Trump was the correct winner under that theory. If that happened, do you think that this Supreme Court would stand in once the states sued the Congress, that this court would step in and say, what Congress did was wrong, Congress has to certify Joe Biden as president? Do you think that this court would do that?
I would hope that Amy would join, and I would hope that Gorsuch would, just because I like the way that he writes. Thomas is never doing it. I don't know. Maybe Kavanaugh would. Maybe you say Roberts is the center of the court. Maybe he would. I don't know, but I don't know. But this is also a reason what you're bringing up now too, and it's something I keep reiterating over and over again. And I've said this in the past, and now I walk it back hardcore. The idea that our institutions survived, our institutions are stronger than I thought, our institutions, right? They're good. But at the end of the day, it comes down to people running those institutions. And there truly were some monumentally important people that were involved in this. A lot of who nobody will ever know the name of, a lot of the White House legal counsel, these guys were fucking heroes, unironically. And these guys are all fucking Republicans too. All of these guys are I don't know if there's a single Democrat in any of this White House counsel. Yeah, they're all Republicans. So yeah.
All Republican MAGA.
Well, I don't know if they were MAGA, but they were Republicans for sure. Yeah, but
I guess it's kind of circular in a way. You're only MAGA if you're with Trump all the time, and so to the extent that you step out of line. You were never MAGA.
Yeah. But have you, dude, so many, I'm getting sent, I don't have the time to listen to all of them. So many of these hearings are wild. Like
I was watching them Vivo. I was watching, so the one that you just, the sanctions motion one, this one, I was watching Vivo and I was just like cheering on the judge. I remember going through all the stages of the Campbell guy, lawyer, and all the ridiculous things he was saying. Yeah, it's insane. People don't even know the 1% of it. It is the most crazy actual conspiracy that really does every. Yeah, go on.
Yeah. No, yeah. Every single part of this that you touch is just insane. All of it. The people that I'm the most jealous of, the lawyers, whatever firm did all the Dominion lawsuits, that had to have been like the most fun that any like law firm has ever had. Those suits are all crazy. The information in all of them, how clear and concise like the lies were, just the insanity from the defendants on all these is just so crazy. But yeah, every part of it is so wild. And even listening to these guys in these hearings where the judge is like, okay, well, hey, so like for this affidavit, do you know if they broke the law? And the people like what was the response? I think this Klein dude said, he was like, well, it's common sense, Your Honor. Like,
yeah. Oh my God.
What? Or like, well, do you know if like, do you know for these affidavits, are these people, oh, you can correct me if I'm wrong here, I guess. So the problem with some of these affidavits is like, so there will be one of the affidavits that went over, the lady, or the person in the affidavit was like, I saw people put bags into a USPS truck and they might have had ballots and I'm not sure what they were doing and I don't know where any of these people were going or I don't know where they came from, right? So that was basically the affidavit. And the judge is like, what are we doing with this? And then the lady's like, well, if you would allow us to have an evidentiary hearing, we can go over these. My understanding for an evidentiary hearing is this is just making sure it like comports with like the rules of evidence and can be submitted to the court. You're never going to like verify or gather more information about like an affidavit or something in an evidentiary hearing, right? Or can you do that in an evidentiary hearing or what?
There's a pleading standard that you have to come to court with. And in the United States, there used to be a time where you could essentially plead anything you want, or I'm sorry, it's the opposite way around. There used to be a time where you had to have there was a big kind of threshold to meet in terms of what you had to say in your complaint. A pleading is a complaint or like the main kind of documents alleging forth the thing or the response. So the answer or the complaint or the cross complaint, things like that, right? Those are pleadings. That's why they call it a pleading standard. And nowadays in the United States, in U.S. courts and in most state courts, there's the notice pleading standard, which means you just need to put people on notice of what the claims are against them. However, there still are certain thresholds of plausibility that you need to reach before you're allowed to come in and have discovery and all that stuff, right?
Yeah.
So, and you still need to allege
a crime,
claim.
Or
in this case, in the civil case, a claim, right? So, when you hear one of the bases for dismissing is failure to state a claim, it is like, as you're saying, right? Like you're not, even if true, the statements you allege are not alleging something cognizable by the court. There is no thing associated with this as a legal matter. You dismiss as like a matter of law, essentially. Now, in addition to that, the court does not need to take or assume the conclusory statements of law made by litigants or anything like that. And things could be such leaps, such speculation that it doesn't even reach the plausibility standard of a motion to dismiss, things like that. So what they're saying essentially here is, even if true, right? Even if true, these claims don't state something for which relief can be granted, and you should have known that.
Yeah,
right?
of course,
You, as an officer of a court, you have a duty to inform yourself and to do the basic amount of due diligence. And for you to come and say, hey, I'm not an expert, I don't know, I just threw something and saw what sticks. They're essentially alleging bad motives in your whole process of getting to court. That's why you're hearing some of the this was for PR, this was for this, and essentially saying to the court or the people on the other side that this was not done in good faith. There was not a reasonable inquiry done to see if these claims even said something worthy of relief.
Yeah.
It's nuts. This entire thing.
Pretty wacky.
Is it making you more or less radical?
Making me more or less radical? I don't know. It makes me hate some people a lot more, and it makes me appreciate other people a lot more, I guess. Seeing that there are a lot of good people in the system that are doing a lot of responsible things. Pence's personal counsel was talking about in front of the committee that like when we were presented with these things, we did like a reading of the entire history to see whenever there had ever been an elector rejected by, the VP. We had all of our people read into this. Like there's a lot of people doing a lot of homework, but there is a lot of, the thing is, Pisco, this keeps happening over and over again, okay? Like this is the thing. The thing is that like Donald Trump this is the deep state. Right? What he's doing is what is being alleged against the Dems, but this is like actually happening. But the problem too is that, and I've always said this in the past, I've always said, I don't believe in broad conspiracies that implicate hundreds or thousands of people because you just can't hide that. It's just not, I don't think it's possible today, but it's happening, but it's not being hidden. Like, again, like we're watching this, all of it is super, super out in the open. This is all like the answers given here are jokes. This is ridiculous.
I want to give you another example of that because it is both massive conspiracies that are coming out and it's projection. So the other example I want to give to you is the Russia story and the Zuckerberg statement. Do you recall the recent statement by Zuckerberg?
Yeah, to fucking Jim Jordan. That Jim Jordan probably came on 15 times before he wiped it off and published it. Yeah.
But hang on. Even except Zuckerberg's statement, conspiracy is Donald Trump and Rudy Giuliani. How do we know that, right? Why was it? Does anyone know? Why was it that the Department of Justice and FBI were telling social media organizations to watch out for a Hunter Biden Burisma story? Why was it? Well, we know from the indictment of Alexander Smirnov, that FD 1023, that prior to those warnings, there was a literal Russian spy trying to feed the DOJ a fake story about the briberies through Burisma and Zlochevsky of the Bidens. We know that, right? He was indicted for that. And the DOJ was aware. So, of course, the DOJ is now aware after having Alexander Smirnov tell them this bullshit story that they're able to debunk. Of course, I would want the DOJ to put our social media companies on notice that this is happening, right? And this is, in fact, the story that they're trying to push. Don't you agree that we would want a DOJ to be like, hey, this fake stories being going around,
and this is one of the things that's so annoying is that there is no good faith assumption from anything, right? Like, for instance, on the COVID stuff, I think that we can all look back, especially when it comes to schools, and say some of the lockdown stuff probably wasn't, it didn't work well, right? We either shouldn't have done it or in the future we won't do it. But rather than saying like, okay, well, a bunch of people got together, they were trying their best, and they made mistakes. It's like, no, it was a conspiracy. It was a massive, broad conspiracy.
But it was a conspiracy, and I'm going to tell you why.
Wait, what was a conspiracy?
Because the next part is going to, for those of you who don't know, it's going to blow your minds. But you all know. The thing is, your brain has wiped it away because there's so much shit.
Oh.
In 2019, prior to Smirnov going to the DOJ, what had happened? Donald Trump, on orders of Donald Trump, Rudy Giuliani had opened a path with the Attorney General Bill Barr to vet his claims against the Bidens. There was a separate whole intake process by which Rudy Giuliani was vetting claims, criminal claims, to the Trump DOJ against the Bidens. And Rudy Giuliani is traveling where? On orders of the President of the United States, Donald Trump. He is going to Ukraine, or sending his cronies to go to Ukraine, to pressure Prosecutor General Lutsenko at the time to announce investigations and charge the Bidens in Ukraine. Who else is he pressuring? He is pressuring President Poroshenko directly to announce investigations, announce charges against the Bidens. And then, in that perfect call, what is Donald Trump doing? Donald Trump is calling President Zelensky for the same exact thing. And so you ask, why is it that the DOJ is warning about the stories of Burisma? Who's pushing the stories in 2019? Who's the one that's trying to get this narrative, this Russian originated narrative? And where is the DOJ receiving all this from? They're receiving it from Russian spies and Rudy Giuliani and Donald Trump. This entire thing was a conspiracy, and it shows, right, this statement, the fact that they're being warned that the underlying conspiracy, that of the perfect call and the pressure campaign against State Department officials and against Ukrainian officials, counter to the interests of the United States, that was being done by Trump, by Giuliani, and their cronies. And so the real conspiracy is the fact that was going on, not that the DOJ was trying to protect the American people against those efforts. And so it's all projection. It's the opposite, right? The true conspiracy are the people going to Ukraine and trying to pressure our State Department officials to come up with a bogus story against the Bidens.
Sure.
It's all projection.
I hear this so much. Greenwald has used this line. That one, was it Lockdoid, or maybe Sean used this line too? Have you ever heard that stupid fucking saying is like, you can indict a ham sandwich?
Yeah, I know it.
It's so frustrating that people will use that. Greenwald did it again on Twitter, and they pretend that like when especially for federal indictments, they pretend that somebody's indicting based on the idea that the highest standard of evidence they'll ever find is the probable cause, right? Like if you can indict a ham sandwich, why is it that, federal convictions are, depending on how you count them, either 90 to 98% from the indictment? Like, are they really just that corrupt, or what's happening? Or is it really hard to indict a ham sandwich, or what? Like, it's such a stupid, but then, so they'll go on like a federal indictment, they'll say, oh, federal indictment, that means nothing. But my God, dude, if you put the right affidavit in front of them, and this is better than like a fucking court conviction. This is better than like a Supreme Court ruling. Like these affidavits, they will hold on to these, or these whatever that statement from the Russian informant guy, like these individual pieces of paper.
1023.
Yeah. These individual pieces of paper will be the most important thing in the world, but everything else, it's ridiculous. I also think, you tell me real quick, if this is normal. Is it normal for anybody else, or has it been ordinary for presidents to retain so much private counsel that they deploy while they're in office?
I'm not sure. Presidents have a lot of attorneys, but it is true that a lot of people have gone after Trump, and so I don't like
not just attorneys, but I mean like attorneys doing professional work. Like for when we talk about like Obama, seeing if he can drone strike somebody, right? He went to the Office of Legal Counsel, right? Is there an example of a president when you talk about Giuliani going to Ukraine? To me personally, that feels like it should be some type of crime, but I guess the president has wide deference to assign people to particular role because Giuliani's nobody, right?
He was the personal counsel to the president.
Well, careful when you say when you say personal counsel, though, that's no White House position, no government position, just like as a citizen, right?
Yeah, that was part of why, if you look at the first impeachment, that's the other big black pill, is look at the first impeachment. The stuff there is insane. Yes, that's why it was called like the shadow Secretary of State. Yeah. He literally had Giuliani acting as a shadow Secretary of State, shadow ambassador, because he was deniable, because it was like the plumbers from Richard Nixon. These are people who are outside of the normal structure of authority of the government, but Donald Trump is.
So there's no oversight. There's no OAG or whatever. There's nothing. They just operate. And then here's a question too.
About deep state, right?
What? Yeah, literally. So not only do they get to operate with impunity and no oversight, are they allowed to claim executive privilege as well, though, when it comes to protecting their testimony?
They tried.
So yeah, it's just wild. It's wild, and this is all. But it's not even wild in like a crazy conspiracy. It's wild in that it's like such an overtly open conspiracy.
Yeah. I mean, I happen to think that the first impeachment, the Ukraine stuff, the Russia stuff that we're talking about right now, that alone makes Trump. You can't elect someone who abuses the office like that. You can't elect someone who is going to foreign countries for their own personal political benefit and deploying the shadow diplomacy to try to announce fake investigations. That can't. Imagine that Joe Biden did that. I mean, like, it is disqualifying, completely to do that.
People will compare everything that Trump did there to Joe Biden being on stage saying, I told him we wouldn't give him the money. Yeah, and it's like, bro, why do you think he's saying that, like, on stage in a public video and nobody cared at the time? Like, don't you think he's representing the policy of the United States? Don't you think he's representing, like, the will of literally the entire European Union and the contingency that we had in place for these loans that were going to give Ukraine if they cleaned up? Like, why are you acting like this is at all? Yeah, this is so...
Yeah, dude, and Dershowitz. I'm going to talk a little bit of smack about Dershowitz. Dershowitz says it's not even a thing to abuse your office, right? You can't even have it that you abuse your office, that it's not impeachable to abuse your office. So we're literally at the stage where Trump's lawyers are arguing, he cannot be indicted for conduct that is he's done in the sort of pursuit of his office, because that would be subject to immunity. He cannot be impeached for using that same authority, because that would be too far. With
the legislature would be placing limitations on the executive that are
And so they're literally saying that you can't even impeach him for it. You cannot remove him from office for abusing his official powers. And if you can't impeach him for abusing his official powers, and if you can't
criminally charge him for it,
then you literally have a king. I mean, that's literally authoritarianism.
I wonder. I don't think it would happen, because it would just be so ridiculous on its face. But I wonder if you could ever get to a point to where somebody tries to impeach like a Republican president, and they said that right, technically for impeachment. Now you can technically impeach for any reason, but the in the Constitution.
Just be real quick.
Yeah.
So separate. I like that you're thinking this way, but just separating your hands in your mind. the Congress can impeach, but they have to impeach for a high crime and misdemeanor.
That's what I was just about to say. I was going to say, yeah, impeachment for conviction of treason, bribery, or other high crimes and misdemeanors. Is there ever a reading here where it's like, well, but if the president can never be indicted for a crime or misdemeanor related to his office, then like, can you only impeach a president if he like commits a felony that like he's like reckless driving or like what would even like he steals or he rapes somebody or it's such a wacky.
I don't even know, but just be careful. It's not necessarily actual crimes. This term high crime and misdemeanor is a term of art which people like Dershowitz don't truly comprehend or understand. But just again, I just want to stress this point. People say you can impeach for anything. That's a shorthand for them saying, well, Congress can impeach and there's no review because it's a political question left to the House of Representatives.
Yeah.
But they're only technically supposed to impeach for high crimes and misdemeanors. It's just they're the ones who decide what those are.
Sure.
And so, yes, what is a high crime and misdemeanor? I think that there is an answer, and I think that if we had the power to review it, that the courts would come to an answer, but the Congress is ultimately the one who decides. If it's the case that you cannot be indicted for an abuse of office, I don't think it necessarily follows that you cannot be impeached, but I think that an argument could be made by people in the Congress that says, hey, if he can't be indicted, then what are we talking about for this kind of thing? And it kind of obviates the whole need for impeachment at all if you can't even do anything about abuses of office, which is the whole purpose of impeachment. I blame that more on like Dershowitz and Trump's attorneys and the people who kind of promote them, that they're essentially making a system where the president is literally above the law in every respect, even with respect to impeachment.
Yeah, and it's annoying because they do this the same way they do with the doctors, the medical doctors that talk about how fake COVID is and fake vaccines are. They'll say things like, well, there are really good legal scholars that say, no, there's not. There's like a few. They've got like a handful of kooks and quacks, right, that are willing to co-sign like these insane opinions, but like the vast majority of the field, legal scholars wouldn't sign on to this. Nobody actually believes this is bullshit, right? They just have a couple people that they found and they're, on their side of the aisle that's willing to co-sign these insane opinions and then be co-conspirators with them. And that's
Who's your dark horse person as part of this plot that you really want to see have justice done? Like not Trump, but like someone who is more like surreptitious or who's not talked about.
For people that should be in jail, I think almost everybody that is anybody that was involved in like any of the filings or presentations. So obviously Giuliani, obviously Eastman.
Oh wow.
Obviously, why would you say oh wow for Eastman?
No, I agree. I just think that's.
I think for Eastman, I think it's even worse because like, did you see the Silverglade?
No, I didn't.
Oh,
I should though, right?
It's not.
What time to watch it?
It's a waste of time.
Don't watch it?
No, yeah, because he's saying you can always give your client cutting edge legal advice. That was basically his whole argument. Yeah, but I mean, he's defending him, so I don't know why he would even do a stream. He's obviously not going to admit that he's wrong about anything. You can't, right? He's just
I mean, the question almost becomes if Eastman had given the advice to Donald Trump, hey, you need to get the military to go inside there and seize all of the senators and install yourself as president. Does he think that cutting edge legal advice would be, and him saying that's not even illegal to do, it's constitutional to do that, you have complete control of the military and you cannot be indicted for use of official powers, would that be immunized?
Maybe. Well, the argument he's making is so strong. There are three huge questions I would have, or three huge points of contention. One, because he was talking about how like, well, how do you think certain, actions get before the Supreme Court or before a court? There's a difference between somebody breaking the law and finding a lawyer versus a lawyer advising you to break the law so that you can go before a court. Number one. Number two, there's a huge difference number two, your lawyer can't just advise you to break any crime. Like you just gave that example. Like you couldn't ask a lawyer like, hey, how can I legally like rape a lady, or how can I legally like murder my wife? And then your court, your attorney like gives you advice to do it and say like, well, I don't know, maybe the First Amendment will protect this, or maybe the whatever amendment will protect this. That's insane. And three, and I think this thing hurts Eastman the most. Eastman was not just an advisor. Eastman was a collaborator and a co-conspirator. He literally worked with Trump the entire time. He was contacting people. He was arguing with people. He was like part of the email chains. He was like working with it the entire time. He wasn't just an advisor. He was like part of the process the entire time.
Yeah. Eastman is a piece of work.
Shit. And Powell too. These people were like, and they were blatantly lying the entire time.
Powell pleaded guilty.
Who?
Powell pled guilty to the Georgia indictment.
Oh, nice. Good. Yeah, she's fucking insane.
So did Jen Ellis.
Nice.
Did you know that?
I didn't know that. Or I know that there are some people that have flipped on the RICO case, but I read that a long time ago before I knew all their names, so I'd have to go back and read now and be like, oh, I see.
Yeah.
Yeah, anybody that was involved in submitting or presenting anything in front of any of these, like state
Courts.
legislatures or anything, not even courts, because a lot of them didn't even make it to court. It's just, like it was all lies and bullshit. And I think that you, at the very least, you should be sanctioned or disbarred because you're putting your reputation on the line. That's part of what you do, right? Like imagine somebody says, "Hey, Destiny, I don't know if this is good enough. Can you come and help me, convince some people on some things?" What you're asking is, you're saying, "Can I borrow some of your reputation and kind of work off your reputation here so that you can support my thing?" Imagine me doing that for somebody and then afterwards going "I didn't read any of his shit. I don't fucking know." Damn. Well, then what the fuck was the point of having my credibility there, right? And it's the same thing with with all of these attorneys, and there are so many of these attorneys. Anybody here, I don't know if they should take an IQ test, and if you're below 75, you automatically get disbarred or something. But the arguments that are being put forth by a lot of these lawyers here, these guys should all be sanctioned or disbarred. I'm sure there are dozens or hundreds of names I don't even know. This Donald Campbell guy, shouldn't be practicing. Julia Haller, I don't know if she's a lawyer. When you're saying things, when a federal judge is asking you, "Hey, how do we even know a crime is being broken here? Did you guys reach out to anybody?" And the answer is either, "Well, it's common sense," or, "Well, we thought that in an evidentiary hearing, maybe we go over that." Like a federal court has infinite time to go through your 1,000 pages of bullshit affidavits to see if they're worth anything or not. These are ridiculous answers. All of these people should be held to account for something. There's no way you could just walk away from this and be A-okay. That's wild.
They should all have things happen to them.
Yeah. It's just...
Yeah.
And
That's common sense.
And it just bothers me because it's so open, and it is the deep. This is this would be the equivalent of the deep state. If it would have worked, this is the deep state, right? Eastman,
That's
you saw
my
that
favorite question. Yeah.
The email, I think it was on the 11th, where Eastman was, I think he was emailing Giuliani, and the third point in the email.
Pardon?
Yeah, he said, "Hey, actually, I changed my mind. I kind of do want to be on that pardon list. So can you go ahead and throw me on that?" What does it show intent? I don't know, but Jesus Christ, bro.